Here's something that might surprise you. A recent global survey found that over 70% of internet users say they've stopped using a service entirely because they didn't trust how it handled their personal data. Think about that for a second. Trust, not price, not features, is now the deciding factor in the digital economy. And yet, most professionals working with data every single day couldn't clearly explain what privacy actually means in a legal or technical sense. That's exactly what we're fixing in this chapter. By the time you finish these lessons, you'll be able to walk into any boardroom and explain why privacy matters, where it came from, how it's treated differently across the world, and why India's own approach is about to change everything for businesses operating here. So grab a coffee, get comfortable, and let's build your foundation the right way, starting from the very first principle. Let's start with a question I ask every batch of students I train. What is privacy? Take a moment. Most people say something like keeping information secret, and honestly, that's where the confusion begins. Privacy isn't about secrecy, it's about control. Think of your home. You don't hide the fact that you live there. Your neighbors know, the postman knows, but you still decide who gets to walk through your front door. That's privacy in a nutshell. The right to control access to yourself and your information, not the need to hide it entirely. When I was consulting for a fintech client a few years ago, their compliance head kept saying, "We have nothing to hide, so why worry about privacy?" I asked him, "Would you be comfortable if I read your salary slip out loud right now?" He went quiet immediately. Nothing to hide, but everything to control. This chapter is going to build that mental model brick by brick. We'll look at why privacy matters practically, not philosophically, how it evolved globally, and how India fits into that picture. Ready? Let's dive in. Why does privacy matter? Let's ground this in something real rather than a textbook definition. Imagine a woman applying for a health insurance policy. Her employer, without her knowledge, shares her medical history with the insurer to speed up the process. Sounds harmless, even helpful, right? Except that history includes a mental health consultation from years ago. Suddenly, her premium doubles and she doesn't even know why. That's the human cost of poor privacy practices. It's not abstract, it directly shapes opportunities, dignity, and safety. Here's why this matters for organizations specifically. Every piece of personal data you collect, an email address, a location ping, a purchase history, creates a responsibility. Mishandle it, and you don't just risk fines, you risk someone's livelihood, relationships, or safety. Think about it this way. Would you want a stranger to know your exact daily commute, your medical conditions, or your financial stress without your consent? Probably not. That discomfort you just felt, that's precisely why privacy regulation exists. So, as we move through this course, keep asking yourself one question for every concept we cover. Whose life does this actually protect? That mindset will make everything that follows far easier to internalize and far more meaningful to apply in your actual work. Privacy as a formal concept is younger than you'd think. It really took shape in 1890 when two American lawyers, Warren and Brandeis, wrote a famous essay called The Right to Privacy, largely because newspapers had started publishing candid photographs without consent. Sound familiar? Replace newspapers with social media and you've got today's exact same debate. For decades after that, privacy stayed mostly theoretical until computers entered the picture. Suddenly, governments and companies could store millions of records instantly. That's when countries started asking, if data can be copied infinitely, how do we protect people? Europe led early data protection laws in the 1970s and 80s. Then came the internet boom and privacy exploded from a niche legal topic into a boardroom priority. The 2018 GDPR was a turning point globally. It proved that privacy violations could cost companies billions, not just reputational embarrassment. Here's the pattern worth noticing. Every leap in technology, be it newspapers, computers, or now AI, has forced society to redefine privacy all over again. And that's exactly why we're sitting here today. because generative AI and India's own digital economy are triggering the next redefinition. Understanding this evolution helps you anticipate where regulation goes next, instead of just reacting to it. Here's a question I love asking in class. Is privacy law the same everywhere? Absolutely not. And that difference creates real headaches for global businesses. Europe operates on GDPR, arguably the strictest framework, treating privacy as a fundamental right, full stop. The United States, by contrast, has no single federal privacy law. Instead, you get a patchwork. California has the CCPA, Virginia has its own act, and dozens of sector laws like HIPAA for health data sit alongside them. Imagine running a business that must comply with 50 different state rules just within one country. Then look at China's PIPL, which blends privacy protection with strong state oversight, quite different from Europe's individual rights approach. Brazil's LGPD borrowed heavily from GDPR but adapted it to local realities. I remember advising a SaaS startup expanding from India into the US and EU simultaneously. Their founder assumed one privacy policy would cover everyone. It didn't, not even close. They needed separate consent mechanisms, different data retention rules, and distinct breach notification timelines for each region. Why does this matter for you? Because India's DPDP Act didn't emerge in isolation. It borrows ideas from GDPR's consent model, reflects US sectoral thinking in places, and adds its own unique flavor. Understanding this global landscape isn't academic. It's the lens through which the rest of this course will make complete sense. Let me tell you about a case that changed everything in India. In 2017, a retired judge named K.S. Puttaswamy challenged the government's Aadhaar biometric identification scheme. The question before the Supreme Court was deceptively simple. Is privacy even a fundamental right in India? Think about that. Before 2017, there was genuine legal uncertainty. The government argued privacy wasn't explicitly listed in the Constitution, so it couldn't be enforced as a fundamental right. A 9-judge bench disagreed, unanimously. They ruled that privacy flows directly from Article 21, the right to life and personal liberty. Why should you care about a court judgment from years ago? Because this single ruling is the constitutional foundation that eventually made the DPDP Act possible and necessary. Without Puttaswamy, India might still be operating without any comprehensive data protection law today. Here's an analogy I use with students. Think of the Constitution as a tree trunk, and specific laws like DPDP as branches growing from it. The branch cannot exist without the trunk supporting it. Every right you'll study in this course, correction, erasure, grievance redressal, ultimately traces back to this one judgment. So when someone asks you why India needed a privacy law, you now have a real answer rooted in constitutional history, not just compliance pressure. Every strong privacy framework in the world, no matter the country, rests on a handful of shared principles. Let's break them down, not as dry legal jargon, but as everyday common sense. First, purpose limitation. Imagine giving your phone number to a food delivery app for delivery updates, then suddenly receiving insurance sales calls. That's a purpose violation. Your data was used for something you never agreed to. Second, data minimization. Think of a library. A good librarian only asks for your name and membership number to issue a book, not your income or medical history. Yet how many apps today ask for your contacts, location, and camera access just to let you play a simple game? Third, accountability. Someone within the organization must actually own privacy decisions, not just a policy document sitting untouched in a folder. I recall reviewing a client's data collection form that asked for a user's blood group to sign up for a newsletter. When I asked why, nobody had an answer. That's what happens without these principles guiding real decisions. These aren't abstract ideas. They're the DNA running through GDPR, DPDP, and virtually every privacy law you'll encounter. Master these principles now, and every specific regulation we study later will feel intuitive rather than foreign. Let's talk numbers for a second. India now has over 800 million internet users, and that number keeps climbing every year. Every UPI payment, every food order, every OTT show you binge watch generates data. That data has become the fuel powering India's digital economy. Here's the tension though, that same fuel, if mishandled, becomes a liability overnight. Remember when a major Indian platform suffered a breach exposing millions of user records? Stock prices dipped, trust eroded, and regulators took notice. That's the digital economy's double-edged sword. Think of data like electricity. It powers incredible innovation, personalized recommendations, instant credit approvals, targeted healthcare interventions. But unmanaged, it can also cause serious harm. Just like electricity without proper wiring causes fires. Why is this relevant to DPDP specifically? Because India's lawmakers recognize this exact tension. They wanted a law that protects citizens without strangling the innovation driving economic growth. That's a genuinely difficult balancing act, and you'll see this philosophy echoed throughout the act's structure. So as we move forward, keep this economic backdrop in mind. DPDP isn't compliance for compliance's sake. It's India's attempt to keep its digital economy both innovative and trustworthy at the same time. Let's bring chapter 1 together. We started by asking what privacy really means and landed on control, not secrecy, as the real definition. We traced its evolution from a 19th century essay to today's AI-driven concerns and saw how different countries, Europe, the US, China, and Brazil, approach it in strikingly different ways. We then anchored ourselves in India's own constitutional journey, understanding how the Puttaswamy judgment made everything that follows in this course legally possible. From there, we unpacked core principles like purpose limitation and data minimization, the same principles you'll see resurface again and again as we go deeper into DPDP itself. Finally, we connected all of this to India's booming digital economy and why lawmakers needed to balance innovation with genuine protection. If you're looking for a fully structured version of this journey, complete with role plays, scenario-based quizzes, and practice tests to truly test your understanding, check out our complete course, DPDP Act Compliance Masterclass on Udemy, linked in the description below. Also, hit that subscribe button so you never miss an upload, and click on the DPDP Act Master Series playlist in the description for the complete video series in sequence. Coming up next, we shift focus to India's own privacy journey before DPDP. See you there.